Smart work week, yeah.
Okay, we'll start in, I guess, in 2 minutes. So we'll start at 2 p.m. sharp. And seeing that all of the panelists are here, I think that would not be a problem, right? Okay. Okay, everyone. So I'm showing 2 p.m. sharp in my time. So I think it's time for us to begin this webinar. First, I would like to do a quick introduction for everyone here. My name is Julian Panto. I'm currently third year undergraduate here at the International Business Law Program at Universitas Prasetiya Mulya, and I have the honor of being the moderator for today's webinar. I would like to say thank you for all the participants who have joined this webinar. Last we checked, we have more than 400 participants joining the registration, and we have some attendees at the Zoom as well as in YouTube as well, which is really great. And I would like to emphasize for the rules for this webinar, which can be seen at this current slide, and for the participants to duly follow the guidelines. Thank you. And before I continue, I would like to inform everyone about LEXINAR. So LEXINAR is a series of webinars by the Law Student Association of Universitas Prasetiya Mulya. And now we are back with our third LEXINAR, and in this edition, we have successfully collaborated with Leiden University for this event. The topic of our current LEXINAR is a discussion on the comparative aspect of contract law provisions between Europe and Indonesia. Today with us, we have amazing speakers from a variety of backgrounds and jurisdictions. We have first Ms. Hetty Roy. She's currently a lecturer and academic coordinator at the International Civil Law and Commercial Law program at Leiden University. She's also currently an executive officer in the Court of Arbitration. Second, we have Ms. Brimantisari. She's currently legal counsel for EMEA and APEC at Corbion. She graduated with a Master of Law from the International Civil and Commercial Law program at Leiden University. And she is also a member of the Indonesian Bar Association. And next, we have our very own Ms. Mulya Yasmin Prisandani, a faculty member here at Universitas Prasetiya Mulya, International Business Law Program, and head of our law laboratory. She obtained her bachelor degree from Universitas Gadjah Mada and her Masters of Law from the International Civil and Commercial Law Program at Leiden University. She's also a member of the Indonesian Bar Association. And last, and definitely not least, we have Mr. Adri Kurnia Ibnu, currently General Manager Legal at PT Kaltim Prima Coal. He's currently also the head of legal committee in the Indonesian Mining Association and deputy chairman of the Indonesian Coal Mining Association. He obtained his Bachelor of Law from Universitas Padjadjaran and Masters of Law from the Business Law program from Universitas Indonesia and also from the International Civil and Commercial Law program of Leiden University. And he's also a member of the Indonesian Bar Association and has a certification in international arbitration from Murdoch University. And I think with that, I want to welcome Mr. Tri Harnowo as the representative from the International Business Law program here at Universitas Prasetiya Mulya to deliver a welcoming speech. And to Mr. Tri, I think the floor is yours, sir.
Okay, thank you very much, Mr. Julian, moderator. Can you all guys hear my voice?
Yes, sir, we can hear you quite clearly.
Okay. Yeah, I'm sorry, I still wear a masker because I'm in outside. So they must be using protocol to wear maskers, but now I have to give a speech. So, okay. Good morning in the Dutch time, of course, and good afternoon in Indonesian time. Yeah. Okay, first of all, I'd like to thank to Leiden University School of Law, Faculty of Law, for this excellent cooperation in conducting this webinar. I, on behalf of University of Prasetiya Mulya International Business Law Program, would like to welcome all participants of the webinar with topic European Perspective to Contract and COVID-19, a comparison to Indonesia. And of course, especially for the speakers from Leiden University, Professor Willem van Boom will give the opening speech, and Ms. Katie de Roy. I'm sorry if my Dutch pronunciation is not so good.
Excellent.
Yeah. As one of the speakers. Okay. Other speakers, Briman Tarisari, as a legal counsel at EMEA and Asia Pacific at Carbion, Ms. Ulya Yasmin from International Business Law Program, University of Prasetiya Mulya, and also Mr. Adri Kurnia Ibnu, General Manager of Legal at PT Kaltim Primakol, a mining company. Yes, where they are all graduate and have studied at Leiden. So this is a Leiden group, I think. Yeah. I myself actually also study in Netherlands, in Utrecht. Yeah, so different camp. Okay. Okay. And also I would like to thanks to LEXIL, yeah, as the organizer. Yeah. I hope that this event can be held with success, and I hope the collaboration between Leiden University, Faculty of Law, and International Business Law Program, University of Prasetiya Mulya, will not end at this webinar, but will continue with other collaboration, maybe, such as research and publication and something like that. The topic of the webinar itself, yes, we are using a legal comparative approach. Yeah, it is very strategic and operational, I think, because by conducting legal comparative, we can analyze the way of thinking of other jurists in other jurisdictions on a specific topic or specific substance of law, where their thoughts and their view can be an input for carrying out legal reform in a country like Indonesia that is making this such comparison, or maybe also known as a legal transplantation, maybe. Yeah. Traditionally, Indonesia modern legal system has originated from the civil law tradition brought by the Dutch when they came to Indonesia. Of course, there must be lots of similarities in legal concept between Indonesia and Dutch. But however, with the changing of time, for example, the development of globalization, made the legal concept of in Indonesia may slightly differ from those in Netherlands on a specific legal topic. That what I have said, that comparative legal studies can be used for legal transplantation as one form of the legal reform, whereby incorporating basic concepts, legal principle, legal provisions, stipulation, or of other country into its own legal system. But the important thing that it must be noted that in carrying out the legal transplantation, we should not just doing it by just mere or bolt transplantation, but we should filter based on our philosophical, sociological, and even political, economic aspect of a country. For example, this subtopic COVID-19, yeah, as the reason for a force majeure is certainly is a interesting topic, yeah, because I read from the term of reference, one of the speaker will talk about the Indonesian president decree that declared COVID-19 as a national pandemic that can establish force majeure. Of course, yes, this is very interesting topic because this brings us back to review again what exactly is the concept of force majeure, or maybe overmacht in Netherlands, or in Europe's perspective, and also in Indonesia perspective. Is it the same concept? Is it still the same concept, or is it different? If it is different, why is it different? Are there any other concepts similar to force majeures? Maybe such as hardship principle or imprevision that can be using by parties in the case of COVID-19? Did the Netherlands or Europe already adopt this principle? Has Indonesia adopt this principle? And if not, why? The importance of this webinar, that's why it's not only interesting in the conceptual analysis, but also this comparative study can also have implication at the practical level. For example, Indonesia President decree that declared COVID-19 as a cause for establishing a force majeure. Yeah, the question is whether this can be accepted in Indonesian court. Maybe what forms of obligation can be forgiven by this force majeure? Whether is it including monetary obligation? And if the case is will be brought in other jurisdiction, for example, if there is a contract between Indonesia party and Dutch party, then the Indonesian industry claim that a force majeure for its contractual obligation due to the COVID-19. How do you think? Yeah, for the example, maybe institution like arbitration institution will respond to this. Yes. This must be a interesting topic to discuss. Because of course there are many interesting topics being brought up by other speakers that I have read. But I think okay, I think that is all I can say. Congratulations again for this cooperation in collaborating in exchange our mind and ideas, and always success. Yeah, but I'm very sorry that I have to leave this precious time. But this, don't worry, because of the technology, I can review it through recordings. Thank you again. Happy webinar. Good. Thanks. Okay, moderator.
Thank you, Mr. Tree. I also hope personally that this will be the first of many collaborations that we will have with Leiden University, and that today's topic will be very relevant in regards with the current circumstances, i.e. the COVID-19 pandemic. And next, we have a distinguished guest who will deliver a welcoming speech representing Leiden University. We have Professor William van Boom. I apologize if I mispronounced that name. He's a professor of civil law and scientific director in the Institute of Private Law, of which he has held a chair in civil law at Leiden Law School since August 2014. So please, please join me in welcoming Professor van Boom. Professor.
Thank you so much, Mr. Chairman. It is a great honor and a great pleasure for us to be here today and to see so many alumni of the ICCL program. It's really a pleasure to reconnect and to share our ideas and thoughts on the global challenge of COVID-19 pandemic for contract law, but also for insolvency law and for, apart from private law, for state aid law, for instance, it is becoming a really great challenge. What we see in the last year is that things have happened which we didn't consider to be possible in the global chain of trade, but also in the local administration of law. What we see in some countries is a high level of activity of governments intervening in the economic processes. And in other countries, governments are less willing to intervene. What we see in all countries, I guess, is that courts will be inundated with issues relating to the pandemic for years to come. I read a particular article by a Dutch law scholar, which was published mid-2020, and he asserted, well, we'll soon be out of this pandemic and then things will return to normal. How wrong was he? I will predict to you that we will have, as lawyers, we'll have to grapple with the issues for years to come. In the Netherlands, for instance, we've seen few insolvency proceedings in the last year. In fact, the lowest number of insolvency proceedings in years. Now that is interesting. Why is it that in a case of a pandemic with a lot of economic upheaval, there isn't a lot of insolvency going on? Well, the explanation is quite simple. The government has been spending billions of euros on keeping businesses afloat. So the insolvency practitioners will have work to do once we're all inoculated and things will return a bit more to normal than they are today. Meanwhile, what the courts have been doing is dealing with a lot of force majeure cases and imprévision cases, so unforeseen circumstances cases. And what we also see is, and I'm sure that Hetty de Rooij will join me in discussing this, is the issue of what exactly is impossibility to perform a contract as compared to, it is perhaps not impossible, but it is a lot more expensive than it was before the pandemic, so it's more difficult. And then you enter the space of hardship as it's dubbed in the common law jurisdictions. Now, those are the things we're dealing with in the Netherlands. And in particular, what we're dealing with is rent cases. A lot of shops and cafes and restaurants have been closed for months and months. But still, the contracts with their landlords, they oblige them to continue paying rent. And a lot of litigation is ongoing on the question whether the landlord should be satisfied with less than 100% of the rent, which was agreed upon. And what we are seeing, I think, is that Dutch courts are treating this pandemic differently from how they've been treating World War I and World War II. in 70 to 100 years ago. And that makes sense, right? The world is different in that respect. And I think the role of contract law is different as well. So that's an interesting thing to keep in mind when you are researching this topic. What are courts doing? And finally, one remark which may be relevant. I told you at the beginning that we see a difference in the level of intervention by governments. In the Netherlands, for instance, there's no government body that will be able to say this is force majeure event. So a pandemic, to announce that a pandemic is a force majeure event is something for the civil courts to do. However, if you look at France, France has an economy which is more directed by the government than in the Netherlands. In France, there is legislation that has provided that the COVID pandemic is force majeure for particular tenants in rent contracts. So the balance between courts and governments there is different as well. That's interesting to note that we see differences in how governments intervene in legal issues as well. So with those short comments, I would like to thank the organization for the opportunity to cooperate on this webinar. And indeed, I hope it will be the first of many. And with that, I wish you a wonderful webinar. Thank you.
Thank you, Professor. I think we've seen how the financial industry, the hospitality industry have all tried to respond to this pandemic. But your comments, it leads us to question, how does the law industry respond to this pandemic? I think that's one of the topics that we will be discussing here today, and what from one of the points you're trying to have stated. And with that, without further delay, I think we should just continue on to our first speaker. I would like to welcome Ms. Hetty de Roy as our first speaker, who will share her perspective towards contract law provisions under European law, especially in response to the COVID-19 pandemic. And Ms. de Roy, I think you may begin.
Thank you. Yes. Well, first of all, we've heard a lot of thank yous, but I'll add one more to that. Thank you for having me today. I'm really delighted to talk to you all, and in particular to our three distinguished alumni who have joined me on this panel. And thank you to the organization for making this possible. It went extraordinarily smooth, and I'm in awe with how you organized this all. So thank you for that. And last but not least, thank you also for Ms. Prisandani for making this possible, and also building the bridge to Indonesia, which is much more difficult for me. So I will focus on Europe, and she will take you to your end of the world, if you will. Now, next slide, please, where you will find a nice photo of me. But briefly, just very briefly, because the program has been mentioned a few times already, so I don't want to bore you with it too much, but I would still want to mention a few things about it briefly, because having worked as a lawyer in private practice for 11 years, I cannot help but be very excited about it. So I wanted to show you a tiny bit what it's about, what courses we offer, and the idea of, our signature approach, which is reflected in all the courses, that for cross-border trade, it's really important to be able to think across the borders and look at law in a comparative way. And our distinguished professors, one of whom you've just met, come from both civil law and common law jurisdictions, which adds a whole nother dimension to that. Next slide. So more concretely, what kind of questions should you think about? Well, these are very basic questions, and they also tie into the topic of today. What laws should govern your contract? That's something you think about at the outside of a contract negotiation, and that's also a time when the issues of today also should be at the top of your head, especially after what we've seen last year. And other questions like, how should the contract be drafted, and what's the relationship between terms of the contract and the applicable law? And I will get to that later. And how do courts or arbitrators interpret those contract terms? Now, understanding different legal cultures, as I said, an awareness of the differences and making good choices in that respect, and similarities also, more importantly, because sometimes we think legal systems work differently, but in fact, they find similar solutions to the same problem. It's important to be aware of that if you're working or thinking of working in international business and you want to advise your clients effectively. If you would like to know more about this, please feel free to contact me. At the end of my presentation, I have my email address for you, and I would be happy to be in touch with any of you. Next slide, please, so that we can go on to today's topic, COVID-19 and the impact on European contract law. Now, I don't know how you all experienced the pandemic so far, and what have been your biggest challenges, but I have experienced it personally as a total shock to the system, from a problem in Wuhan that seemed local, that revealed itself to us in January of last year. It seemed to be knocking on Europe's door within days, a matter of days, really. And initially, we tried to ignore it a bit, but by the end of February 2020, the consequences of the pandemic were basically felt everywhere in Europe in a very severe way. Now, I chose this photo in the end, even though I thought about showing you one of the pictures that I took of a supermarket with empty shelves. I made the mistake of going into a supermarket thinking I could just get some stuff for dinner. And people in the Netherlands went to the stores and raided everything that was durable. Also funny things, crisps. I thought, not sure how that is essential, but it really scared me. But I chose this photo in the end because I think for international trade, this is what the world felt like. It was temporarily closed. A lot of production happens in China, so that consequence was immediately something that people got concerned about, and also was a real problem initially. But the Chinese government got things under control rather swiftly, actually, and then other problems ensued. The container transport became unbelievably expensive. The economies closed in at least in our part of the world: schools, offices, restaurants, bars, hairdressers, and in some countries even non-essential stores. The approach was not a single one in Europe, as Willem already mentioned, with regard to government intervention in contract law, but the same was true in the economic interventions. In the Netherlands, stores stayed open by and large, and it was pretty mild, whereas in Spain, for example, and Italy, people were locked up in their houses. Next slide, please. So what's important to know about COVID-19 and contract law in Europe is that there was not one single European approach, even though if you look at our systems, they're pretty similar. If you look at it, if you compare it with worldwide, they have similar origins, and in that sense look a lot alike. We saw a lot of different approaches here. And in France and Italy and Germany and Belgium, the governments very quickly issued very specific regulations addressing contractual performance, or rather non-performance, as a result of the pandemic. To give an example, in France, there was an ordonnance. If you want to know the specifics, it's 2020-306. And that allowed, for example, the delayed payment of contracts, or the delayed performance in general, and that could not lead to liability. Now, the governments of, for example, England and the Netherlands took a very different approach. They did not issue any regulations. The UK government issued a note advising parties to act responsibly and fairly. And in the Netherlands, we have now recently seen some activity on moratoriums on bankruptcies and enforcement measures, but no general rules that permit delayed performance, protecting contractual relationships in a sense. Now, and all this while, parties were faced with market circumstances that had altered beyond their wildest expectations. I mean, the prices for some commodities went up in a way that was unexpected and also beyond people's imagination, I think. And for products that were all of a sudden in much demand, like sanitizing products or masks, the prices just went through the roof. Next slide, please. However, given the lack of government intervention in some jurisdictions, parties had to fall back on their contractual arrangements, but I will come to that later. And if those were not sufficient to the applicable law to their contract. Now, the most important doctrines that could be of help to parties there are the ones of force majeure, already mentioned, and hardship or unforeseen or changed circumstances. Now, I've included here a provision from the principles of European contract law, not because they apply. They're not mandatory law. Parties have to agree on applying them, and I don't think that happens an awful lot, but it's the closest we have to a unified European contract law. And it's the result of attempts in Europe to harmonize what we're doing here. And these were drawn up by academics and were intended to be applied as sort of general rules of contract law that could be used by parties. And they as such represent a form of consensus or a common denominator of European contract law, if you will. And I chose to show you this because this is a force majeure clause. And as you can see, it excuses a party's non-performance if it can prove that it's due to an impediment beyond its control that it could not reasonably have been expected to take into account at the time of the conclusion of the contract. Now, an impediment, as was already mentioned, is an obstruction, is an impossibility to perform. It's a really high threshold. Did the pandemic cause such an impossibility to perform? In some instances where there was an export ban on now vaccines, which is sometimes in the newspapers at the moment in Europe, yes, but where certain things were forbidden by government intervention, yes, but often performance had just become more burdensome, more costly, different from what the parties had envisioned at the time when they concluded the contract. And also these force majeure clauses, and I will get to the UK counterpart in a moment, they don't result in adjustment of the contract, but the only remedy basically, it's a shield from claims for performance or damages, but the remedy that is still at the disposal of the other side is to just terminate the agreement. So that is not ideal, because then you're back at square one. Next slide, please. So under English law, when circumstances change significantly so as to make performance impossible, basically, the only remedy in principle that you have is the doctrine of frustration. And that automatically brings a contract to an end. So whereas under Dutch law, force majeure, there's still the option for the other side to terminate. Under English law, it's an automatic result of invoking this doctrine. And it does not permit adjustment. The threshold is also, again, really high, impossible, illegal, or radically different. And the outcome is just a hard sword that cuts through the contractual bond. Now, there is a solution to this problem, and that's in contract drafting, and I will get to that later. But as you can see, this situation for contractual parties in England is not ideal. And I would like to go on to the Netherlands now at the next slide. Because there we have adopted in 1992 a provision that allows for adjustment of contracts, unforeseen circumstances. It's relatively new provision, less than 30 years old, but it sort of seemingly allows for a safety valve. But you have to know, I will look at the criteria in a moment, but that the threshold is still high. But it leads to adjustment and not to termination. And a similar doctrine already existed, developed after the Second World War, based on the good faith principle. And that reflected the fact that in case of truly changed circumstances, a reasonable party cannot hold the other to the concluded contract. Now, if we look briefly at the requirements, it requires unforeseen circumstances. Now, what that means is future circumstances that were not taken into account when the contract was concluded. So not necessarily truly unforeseen circumstances, because a pandemic, you could argue that there would be a pandemic, people have warned for that for years now, I think. We've never truly believed it, that it could happen, but it was not truly unforeseen in that sense. And that is also not required under this provision. Now, they must be of such a nature that unrestricted adherence to the contract cannot be expected. And that's where the high threshold comes from. And to give an example, the financial crisis of 2008 was not considered something that was considered a risk that parties assume, and that is just part and parcel of a commercial party's deal, and not something that is unforeseen, that there is an economic downturn every now and then. Equally, payment difficulties also do not qualify. And the risks should not, that's the second leg of this provision, remain for the account of the person invoking the provision. Now, if all the requirements have been met, and as I said, the burden of proof is on the party invoking this provision, and it's quite high. But if the party manages to convince the judge, then the court's task is to amend or change the contract in a way that reflects what parties could have reasonably expected from each other. Now, it goes without saying, I think, at least for me, that most commercial parties are not too keen on giving a court these discretionary powers. And as a result, I think, and that is my next slide, case law so far has been rather modest as a result of COVID. Now next slide, please. Now we may see more litigation in the years to come, or we probably will. But at the same time, because unforeseen circumstances, you basically put your faith in the hands of the judge. Of course, parties can indicate what they would want to see change, and I'm sure every judge will also look at this very carefully. But in principle, it's up to the judge to decide what they do with the contract. Now, we have seen case law quite a lot already about rental agreements of restaurants, bars, and hotels. I think there the situation was also of such an urgency that they resorted to interim relief proceedings. And there have been now some judgments also on the merits, but I think the urgency of the situation probably caused also this wave of litigation. And in those cases, the verdict of the courts has been almost unanimously that COVID-19, and particularly the measures taken by the government, constitute unforeseen circumstances. Interestingly enough, though, and that comes to the point that Professor van Boom already mentioned before, there were also instances where hotels closed voluntarily. And that would not qualify as force majeure, but they did manage to get a rent reduction under the unforeseen circumstances provision. And the solution of the courts has by and large been to share or divide the pain to some degree. And that has also been advocated for by some scholars in the Netherlands. But others argue that this is not actually workable, because what we have seen is courts struggle with what actually is the pain caused by COVID. There needs to be causality, and it's been difficult to really properly weigh the contractual equilibrium, because there might also be pain on the other side. And that is currently not taking into account. And then the government has also, it's not been active on regulating contract law, but it's been very active in giving support to parties. And that also has to then be factored into what is actually the pain that a party is suffering. But we've seen rent reductions temporarily for the period of lockdowns of up to 50%. Now, I have to think about my time a bit, I think. I had a few comments on how I think it's important to bear in mind with litigation that there's always a delay, so that we may see different developments in the years to come, because for cases to start and to run its course and for judgments to come out, that always takes a bit of time, lead-in time of at least a year, if not longer. And as I said, I also would expect that many companies actually manage to agree on a solution amongst themselves, if not. So you raised your hand?
Oh, sorry, I clicked that on accident, sorry.
Okay, no problem. If not least because one of the parties sometimes has a bit more negotiation power than the others and can impose its demands on the other party. For example, one of the biggest supermarkets has indicated that it will impose a fine on, it has introduced a corona fine, fining companies who are delayed with their deliveries. That's also a way of solving, I guess, the consequences of the COVID crisis, or at least redistributing the pain as a result of it. Now, next slide. With respect to unforeseen circumstances, what is always important to bear in mind is the different time frames. Who knew what when? When will the uncertainty end? I, for one, I would not want to make any predictions on this. Will this year be very different from last year? What will we think when we look back at the end of 2021? Will there be future government intervention? And last but not least, how can you protect your client from future shocks of the type that we've seen last year? Now, next slide, please. What you could think about when drafting contracts is very actively what your client needs to be okay in the next few years. Now, of course, we can't look into a glass ball, but there are clauses that are crucial in some jurisdictions, like in England, where you really should think about whether you don't need a hardship clause or a price adjustment clause or any other arrangement that mitigates the hard consequences of frustration. But given what we now know about what could happen, these clauses deserve extra attention. And next slide, please. I wanted to point you to the International Chamber of Commerce. They very helpfully were very proactive, and in March 2020 immediately came with adjusted force majeure and hardship clauses. And this is the hardship clause, and it allows for tailor-made remedies. I've not included them here, but it's worthwhile to have a look at them and use them as inspiration. But you always have to bear in mind whether these clauses work under the law that you chose to govern the contract or agreed on. Now, I will not spend much more of your time, but we'll make room for the far more interesting stories from the battlefield that Ms. Karta Meja will share with you, who worked as an in-house lawyer in the Netherlands at the time the pandemic hit, and who experienced in real life what issues companies faced at that moment. Thank you so much for listening to me, and I'm looking forward to the discussion later. I'm happy to take on any questions. Thank you. Oh, and my email address is on the next slide. So.
Thank you, Mr. Roy. I think it was a very eye-opening and insightful presentation, and to look how the approach from the Netherlands in response to this pandemic. And also, I'd like to point out a question that you mentioned. Does the pandemic make it an impossibility to perform obligations? And I think this is a question that many jurists from all jurisdictions are questioning in our current time. And next, we have Ms. Brimanti. And this time, Ms. Brimanti will share her thoughts on the company's response to the COVID-19 pandemic situation in terms of enforcing contracts. And to Ms. Brimanti, I think you may begin.
Yeah. Good afternoon, everyone. My name is Brimanti. You can call me Bri. And thank you for having me. Thank you for University of Leiden and also Universitas Prasetiya Mulya that held this webinar. So my role here is actually to represent the point of view of someone who works as a legal counsel in a multinational company, especially in Europe. And I'll be sharing my experience so far. So I don't see my slide yet. Can you share it probably?
Yeah. Can the committee make it to a full screen? So we get a work. Yeah. All right.
Yeah, next slide, please. So a little introduction about myself. It is important to know actually what kind of company that I work for, so you can actually imagine the type of cases that I typically handle. So I started off my career as a corporate lawyer in Jakarta from Makarim Taira Consular Law, where I gained quite broad of experience. I worked there for 3 years, and then 5 years ago, I moved to the Netherlands to pursue my master's degree. So I joined International Civil and Commercial Law together with Mr. Kurnia and also Ms. Yasmin. And from there, I gained quite a lot of knowledge about the European perspective. I built a solid networking, and also because of I studied in ICCL from University of Leiden, shortly after graduation, I got a job offer from HMS International. It is a food and beverages operating company that focused on the travel hub location. So for example, like airport, station, terminal, and it has subsidiaries in 19 countries, and one of them being in Indonesia. For example, if you go to Soekarno-Hatta Airport, you see the outlet like Journal Coffee, Colette Lola, and if you go to Amsterdam, you see Burger King. Most of the time, they are our operations, so we're acting as a franchisee. And you can imagine a similar company in hospitality like HMS International has been suffering a lot of loss because of the lockdown and COVID in general. And luckily, after that, shortly after the COVID situation happened, I changed my job. I joined Corbion shortly, and it's a biotechnology company that manufactures the ingredients for multiple range of products, for example, like pharma product, food, bakery, biomedical, personal care, and whatnot. It is a publicly traded company in Euronext. And when it comes to my position as a legal counsel, I have been experiencing the impact of the outbreak to my day-to-day work since March 2020. And the interesting part is the dynamic between those two employers are very different in my way to approach the COVID-19, because it does affect the companies, but in a different way. And I learned a lot. I will share with you my insight that I've been gaining so far. And I would like to emphasize that I'm not representing any of my employers before, Corbion or HMS Host, in this webinar. So what I express here is solely my own opinion. And can you please the next slide? Yeah, and in this topic, I'd like to break down the stages into 3. Ideally, it started with the drafting of the force majeure clause, of course, the contract, and in a contract, we usually have the force majeure clause, and then we negotiate the contract with the counterparty. And most of the time, it doesn't get into the exercising point yet. And when I was working as a lawyer in Indonesia, not a single case I have handled is remotely related to force majeure. So I've been taking it for granted, because when you review a contract, you just want to make sure that, the force majeure clause is in place, and you always have the standard wording. As long as it's general enough and broad enough, I don't think it will never happen. And I never really amend it and have a concern about it. As long as it's there, it's good enough, right? So something that you never thought it would happen, it becomes a thing that affects you greatly, not only professional life, but also personal life. I think many people can agree with me to that. And ideally, you will start the stage with drafting. But in this time, I would like to reverse the stage based on the real experience that I have. So next slide, please. Yeah. Exercising the force majeure clause. And if you look at what happened last year, COVID-19 was confirmed to have spread in the Netherlands around the end of February, as Hetty already mentioned. And that point, the impact started to affect the business of my employer. And everybody just like really panicked, like what could happen, it's pretty unclear at the beginning because we don't know yet. The number of cases is not really that high. We just know something that happened in China and lockdown. And we're just wondering, will that affect the Netherlands majorly? And I have learned that in this case, usually the business owner or the company that you work for, it is important to perform a risk assessment. Typically, you try to answer the following question like, does the outbreak affect the business? In the Netherlands, the business like Horeca, Horeca is abbreviation of hotel, restaurant, and cafe or hospitality business, or a business that needs the physical contact like salon, massage place, are greatly affected. For example, because of the social distancing and the safety policy for Corona. And how does it really affect? But in this case, you have to see in two perspectives, internally and externally. Sorry. Internally means that how does it affect the working environment in your organization? How do you regulate the social distancing in the office? Because normally in normal days, I will sit side by side to my colleagues and easy to talk to them. And because of the Corona, then nobody can be able to sit next to me because that's the policy. And even as simple as you're going to the toilet, the company has to make a route so that you don't pass the other person from the other direction. It really affects you like in day-to-day activities actually. So when you see externally, how does it affect the relationship with the business partner? If you work for Horeca business, you may have relationship with the landlord, the place when you run the business. For example, for HMS Host, we have a relationship with the airport, for example. And if you sell the product and if you produce a product, then how is the relationship with your supplier? So how does it affect the delivery time? Will there be any delay because of the lockdown? And also ultimately the relationship with the franchisor, because HMS, my previous employer, acting as a franchisee. And the other question, if it doesn't affect you now, will the outbreak affect the business in the future? I can imagine for IT companies, for example, you just provide like some kind of IT services. I'm not like IT savvy or something, but I can imagine it may not affect them that much compared to Horeca business because the physical contact is very minimum. But in general, what happens if numbers of employees are sick and could not meet their deadline for their customer? Of course, usually in IT, you have deliverables that you have to perform within certain days. But if most of your employees are sick, how can you do that? Then you will end up in breach of contract, right? And the question is, what are the risks in the future? Are you going to lose a lot of money? Are you going to keep the contract? Are you considering to terminate the contract? So it's again usually coming from the business development or the business side of the company. So you have to really communicate with them, and usually they make some assessment or some kind of business case to see the foreseeability of a certain project. And internally, you may think that, for example, Horeca, we have to terminate a lot of employees, for example, the waiter, because we don't need as much as people to work in the restaurant, right? And how do you reduce is it possible to reduce the salary? And is your company is actually eligible for support from the government, like has been mentioned by Professor Willem van der Boom and also Hetty. And if we're talking about insurance business, for example, the nature of COVID-19 pandemic has meant that it has affected many lines of business where there is insurance coverage. For example, the affected area, business interruption, for example, disruption to the supply chains and inability to operate as normal due to the government measure. Because for your information, in the Netherlands, in winter time, we have curfew until 9 p.m. And then in springtime, they changed the regulation because, sunset will be later. So the curfew time is 10 o'clock. So it may affect the delivery of the supply chain, right? And the second one is, for example, trade credit insurance for the delay of a payment. Sorry. And also another example regarding the cyber liability due to the increased working from home situation. So it also affects budget to provide more reliable IT support, right? So they have to provide you with a laptop and probably giving you compensation for your internet expenses, something like that. And if you see Wimbledon, for example, the world's oldest tennis championship held in London every June, I really like it. The pandemic insurance for the event is expected to result in 120 million, if I'm not mistaken, due to the cancellation. So as a result, pricing or premium for insurance can also be more expensive. Those are the example, what are the risks that you may see. And the other question regarding the mitigation, when you know the risk, we should think of how you mitigate the foreseeable effect. If you work for a really good company, the company will also think about your mental health, for example. The HR will always contact you about how are you doing and stuff. That is just a simple example internally. But outside, you have to see, like, can we do something to actually protect the business or prevent more losses? And as a legal, your part is to do the examination. Of course, you will go back to the contracts. What are your rights and obligation? And I know that if your only obligation is regarding the payment, whatever that is, it may not be waived due to the force majeure clause, but it depends again. So you have to check all the rights and obligation there. And of course, you check whether you have the existence of the force majeure clause. Because if you don't, then you will see what is the governing law, as Hetty already explained. If, for example, it's governed by the English law, then you have to refer the doctrine of frustration, right? So, but it will always be useful to have force majeure clause in place. And you check the requirements. When you have the force majeure clause, you see what are the requirements so that you can exercise the force majeure clause. For example, I will get to the samples shortly, but just for information, usually you are required to notify the other party within certain time if there is a force majeure. Exit strategy. For example, if you see that this is not going to be really good for the business, you have to check whether you have the termination right due to the force majeure. For example, if most of the cases that I see is that if force majeure lasts for more than 6 months, then either party can have rights to terminate the contract. And the question is, do you want to exercise that? Is it good for the business? It depends. And relationship with the stakeholders, of course. Why is it important? Because from my experience, we have experienced relationship with the landlord and also with this franchisor for a long time already. And they can be quite flexible in that sense, so we can negotiate better. But when you do not have good relationship with them, even to prove the occurrence of force majeure can be difficult. And again, it comes down to the business judgment from the company. So you can always, as a legal counsel, you say like, okay, we have the rights to terminate, we have this and that, this is the solution. But again, it's your call to actually think whether you want to is it necessary to actually exercise the force majeure clause. And well, actually, in the Netherlands, I noticed there is a artificial intelligence service in the contract management system to review or analyze the contract, because probably if a small company, they only have like traditional file, you have to check all the contracts, and as a legal counsel, you are actually obliged to check all the contract. But when you have the AI, so to say, and it really helps you a lot, because it can summarize all the contracts, whether they have the force majeure or not, and you see the overage view of your business. So yeah, just for your information, it really big in the Netherlands, but I don't know now how is it in Indonesia. So next slide, please. Yeah, I've prepared you 3 samples. First sample, this is from lease agreement. The governing law is English law. So you can actually get it from the internet if you would like. But if you see the red line, it's actually the important keywords. So neither party shall be liable to the other party if there is a breach of of this agreement, whether either party is unable to carry out any of its obligation under this agreement due to an incident of force majeure. So you go back to the definition of force majeure. And most of the time, more often than not, they always define it as event or occurrence outside the reasonable control of either party. To me, that's good enough, because it's actually cover everything. So you can always say, yeah, that's beyond our control, so that's force majeure. But also, I found that some of the contract I see wording of restraint of the government or public authorities. So when it is really hard to prove that COVID-19 is actually force majeure, you can always go to this wording. And especially in Netherlands, there is a lockdown and curfew, and you can always say that is actually force majeure, right? When you don't have this clause in your contract and the governing law is English law, then you have to go back to doctrine of frustration. And it is actually similar to the New Zealand law. I have that experience as well. I take a similar approach. They don't have the clause for force majeure, but then you have to check the doctrine of frustration there. And just because you're I work in legal counsel for region of EMEA and Asia Pacific, doesn't necessarily mean that I know every law. It's impossible to know every law, right? So don't worry about it. What we do as a legal counsel, usually we do the preliminary research check. For example, the governing law is New Zealand law. So you just check what is the concept there? Is it force majeure, doctrine of frustration? You can always compare, right? And you have the main idea, and then the company can always negotiate, or if it's really necessary, you can always engage with the local lawyers. Second one, the second one also, all the sample I got is from lease agreement. I did not refill the governing law, but I can say that this is in one of the Scandinavian countries. And you can see the force majeure clauses is really interesting, because it only talks about your rights to renegotiate regarding the minimum annual guarantee. So let me explain. The lease agreement is between the landlord, which is the airport authority, and my company, or the company that ran the business place there. And for paying the rent as a F&B outlet in the airport, usually it is regulated under certain payment schedule or payment scheme, where you pay when you pay actually based on certain percentage of minimum annual guarantee based on the revenue that you get. And also the interesting part is that they exclude the certain definition of force majeure. So if it's not resulted in a decision by the landlord to deny the passenger, it's not a force majeure. But it says here that you have other rights for the remedy, so you always need to check. And next one. So this is the Indonesia. You can see that not more than 72 hours to notify. But then the question is, when do you define that force majeure is actually occurred, right? That's the question. And next one, I think I'm running out of my time. So the challenge is, what I found is the evidence. You can imagine it doesn't go smooth as you think, especially at the beginning of COVID, because some of countries are more ahead of the game than other countries. For example, like Vietnam, they closed down, they had the lockdown really early for a certain period of time, and now they're fully operated, just like in New Zealand as well. And you are required to prove actually that your failure to perform was due to event beyond your control. And at that point, it's kind of hard because the landlord doesn't think that COVID is force majeure. So what I do is that I collect all the official statement for WHO, and government statement, for example, presidential decree regarding that says that, okay, COVID is force majeure. I also gather information to compare with other neighboring countries. For example, if it's in Indonesia, I gather information from Vietnam, from Malaysia. How do they approach so that landlord can accept that it is actually force majeure? Maybe not now, but maybe in coming weeks. And the challenge also, the lack of precedent at the beginning is kind of hard to actually see what will happen. And having that knowledge and experience, how you exercise the force majeure, has changed the whole perspective of drafting it. So I don't take it for granted anymore. Can you change the next slide, please? Yeah, I don't want to explain much about this because Yasmin will explain about this. So force majeure is governed in Indonesian law, basically open principle. You can make any agreement that you want as long as it meets the requirements of valid agreement and doesn't violate the public order and decency. This is just a sample that is really normal. And the next slide, please. Next slide. Okay, regarding negotiating, it is important to remember, is it a new contract or an existing contract? Because it may affect your bargaining position. When you already committed on certain things, it's kind of hard to say no or to argue. And when it comes to new contract, well, you haven't done anything yet. You can always negotiate what you want, right? But that's not always the case. And is it about the payment obligation? Can you actually waive your do you have the negotiation rights again when it comes to force majeure? And the most important part is, do you think that COVID now is still considered as unforeseeable circumstance? I don't think so, because we've been living with COVID for almost more than 1 year. So it does really affect how you draft the contract, whether you want to include the wording of pandemic or you want to exclude it. And then the last one, things you want to exclude. For example, your company doesn't think that COVID is not unforeseeable anymore, so it's not going to be like force majeure. So put it in the draft, just like what happened in the Netherlands with the supermarket. If they have the delay, it's no longer a waive because of the force majeure. So if you see here, they exclude anything related to illness, strike affecting only seller, the employee shortage, but not about the COVID, raw material shortage. Business shall not consider as force majeure effect. And last one, please, I think. Yeah, and this is what I would like to do. If you don't know, well, not sure, and you don't want to terminate the contract, please always mention that both parties shall discuss to find a mutual solution in order to perform the agreement. I think as long as the way you draft it is mutual, I think it will be more acceptable for both parties. So yeah, I think that is my insight. I'm sorry if I don't explain you the whole thing, but yeah, that's what I experienced. Thank you.
Thank you, Ms. Primanti. A very interesting presentation. I'm sure a lot of people here are willing to join into this discussion. We see there's already questions, but we'll be discussing the questions later on at the end of the webinar. And yes, I think for a long time, force majeure clause in contracts has been somewhat of a boilerplate, and now it's turning to the belle of the ball. And I think this is a very interesting topic that we will discuss later on. And Next, we have our very own Miss Mulya Yasmin Pisandani, which Ms. Yasmin will share her perspective on the comparative update on contract provisions in the Netherlands Civil Code as compared to the Indonesian Civil Code. Thank you. Ms. Yasmin, you may begin.
Thank you very much, Julian, for the time. And again, a lot of thank yous, but I would also like to thank the participants, law students, fellow colleagues from legal practitioners and legal academia that have been so kind, making their time available on a Saturday to watch us talk and share our perspective in this LEXINAR. So applause for us all. I would just like to briefly provide a bridging from the discourse on European and Dutch law into the Indonesian law. And as such, next please. Yeah, just a little bit of an introduction about myself. As has been elaborated by Julian, I'm the head of law laboratory and a faculty member in the International Business Law program of Universitas Prasetiya Mulya. And as the name implies, our program focuses on international business law. So I mainly teach courses that are relevant to commercial law, but that includes foundations of comparative law, corporate mergers and acquisition, as well as business law. However, today's topic is very interesting for me because my research interest is actually on comparative commercial law. And that includes comparative contract law, comparative corporate law, and comparative corporate governance. And aside from my law teaching, I am also a licensed advocate from the Indonesian Bar Association, or the Peradi, as well as a licensed mediator from the National Mediation Center. Next, please. Right. So just as a refreshment, I would like to start off with this very beautiful picture of a typical scenery in the Netherlands. When you walk across the street, especially in Leiden, you will see Dutch bikes, very beautiful buildings with pastel colors and canals, and you will really be able to enjoy the day. But on top of that, my question is this. Is it true or false that the civil law provisions that are now applicable in the Netherlands also still apply in Indonesia because of the shared legal history? And why do I ask this question? This is because it is a common misconception for some people, since the Indonesian law uses the old Dutch law, that they still think that it is the same law. So next slide, please. It is not really the case, actually. So I have observed two main differences with regard to the divergence between the Indonesian law and the Dutch civil code, civil law, with regard to, the development from our independence. As you may have known, our Indonesian civil code has not yet been amended, revoked, or renewed since 1847. And as such, most of the, someone is raising their hand. Will it be addressed later, Mr. Moderator?
I think so, yes. We will address all questions later.
All right, so if you have any question, I think you can just type in the chat box, and the moderator will address it later during the Q&A session. All right, where was I? Right, so the provisions from the old civil code is pretty much still applicable due to concordance principle, in which it basically stated that all the prevailing laws and regulations that were there during Indonesian independence will remain applicable unless the newer laws amend or replace it. However, as Ms. Hedy also has explained, this is not the case with the Dutch Civil Code. The Dutch Civil Code has undergone a substantive amendment in 1992, but to the extent of my knowledge, there has been several other renewals, including the addition one of which in 2012, they added Book 10 on conflict of law. And if we compare it back to Indonesia, up until now, we still have yet to have our own conflict of law codes. So that is one of the main difference that I think it is important for law students to know, that we have gone our separate ways with regard to the civil codes. And the next significant difference that I have observed with regard to the development of civil code between Indonesia and the Netherlands is that our Indonesian civil code is amended and supplemented with provisions that are mostly accommodating domestic interest. And as has been explained as well by Ms. Hedy, you may all are aware that the Netherlands is part of European Union, right? And the European Union, they have their own set of international rules, European Union regulations, European Union directives, and as such, you can really see that there is an attempt to provide an international standard, a uniform standard in many things. For example, in contract law, through what Ms. Hedy has explained in the principles of European contract law, and as well in the common European sales law, for example. Next slide. Right. So moving on to the civil code and COVID-19. There are two basic legal principles that I would like to start off with regard to contractual adjustments in the time of COVID-19 pandemic. So on the first hand, we have Pacta sunt servanda. I think most law students here are very familiar with this. I think this is one of the most, oftenly repeated legal principles in your civil law courses or in your contract law courses. It literally means that agreements must be kept. So parties are not allowed to deviate from what has been agreed in their contract, regardless of the situation, and that the agreements must be, executed with good faith. And as such, the change is not possible. But on the other hand, we also have the rebus sic stantibus legal principle. It literally means things thus standing. So the contractual provisions are only applicable in the same condition when the contract has been concluded. So with regard to COVID-19, if we refer to the rebus sic stantibus principle, therefore, since there is a fundamental change on the situation, then the contractual obligation may be adjusted or deviated. Okay, next slide, please. Right. So one of the most important provisions with regard to these two principles is Article 1338 of the Indonesian Civil Code. It states that all valid agreements apply to the individuals who have concluded them as law, and such agreements are revocable other than by mutual consent or pursuant to reasons stipulated by the law, and that the agreement shall be executed in good faith. As Ms. Brimanti has addressed, if both the parties negotiate and they have mutual consent to, adjust the payment, adjust the obligation, then our discussion will be short and straightforward. But a lot of times, that is not the case. One of the parties may be hesitant to relieve the other party from their contractual obligation, despite obvious hardship or impossibility that is caused by COVID-19. So we would have to look at the law to see whether or not the force majeure situation or requirement is already fulfilled. Next. Right. So the question for that would be, which laws and regulations should I look at if we are to, if we want to analyze about contractual adjustment because of COVID-19? So first and foremost, as Ms. Brimanti has also addressed, we should look at Article 1244 and 1245 of the Indonesian Civil Code. This is related to enforceability, and this will be further explained by the next speaker, Mr. Adri Kurnia. But with regard to the general concept of whether something is, imposes restriction or imposes a fundamental change in situation, we would have to look at health-specific laws, such as Law Number 4 of 1984 on infectious diseases, in which we can infer that COVID-19 actually fulfills the definition of infectious disease as provided by the law, and as such, there are certain impacts that can be produced since COVID-19 is declared as an infectious disease. And there's also Law Number 6 of 2018 on health quarantine, because as you all know, Indonesia, I think a few months ago, we went through the large-scale social restrictions, and of course, that also impacts business practices in various ways, that it also affects contractual obligations and implementations. With regard to the large-scale social restriction, I think one of the most relevant legal source is the government regulation number 21 of 2020 on large-scale social restrictions in the context of accelerating the management of COVID-19 disease. Because in the government regulation, the requirement of physical distancing and not really opening businesses was elaborated. And last but not least, we should also look at Presidential Decree number 12 of 2020 on the determination of COVID-19 spread as a national disaster. Next. So once we look at these laws, what kind of questions should we ask? We can make an analysis on whether or not the COVID-19 pandemic can constitute as a force majeure. And the first question that can be asked is whether or not the requirements of force majeure is fulfilled with the existence or with the spread of COVID-19. And second of all, we can also answer the question of scope and limitation of such force majeure, and as a result, which specific activities or industries that can fall within the force majeure scope of COVID-19. And last but not least, we can also explain about the impact of relevant laws and regulations on contractual obligations in general, because as we can see, the COVID-19 pandemic has been going on for so long, right? So it is not only a temporary condition. We can also look at how this will change contractual obligations in the future in general. Things may not be, done the same anymore. So we can also analyze what is going to happen in the future. All right, so most of this analysis will be presented by the next speaker. Next slide. But if you have any questions, please don't hesitate to reach out to me through this email. And thank you very much for your attention. Thank you very much for your time. And I give back the floor to Mr. Moderator.
Thank you, Ms. Yasmin. That was a brief, but I think quite concise and quite informative presentation on looking on how Indonesian law regulates on contracts. And at the beginning of your presentation, I caught note that seeing how the Dutch Civil Code has actually gone to substantial amendment, and we're still stuck with the Napoleonic Code back at the 1800s. So I guess now we'll continue on to our final speaker, which we'll discussing on a more practical aspect, which is the presidential decree. And I welcome Mr. Adri Kurnia Ibnu.
Thank you, Mr. Moderator. My name is Adri Kurnia. I'm working as a in-house counsel in mining companies, and I think today I'm gonna maybe bring or share a bit of my perspective on the COVID spread, whether and how usually typically mining companies or maybe in-house counsel deal with this pandemic. Can we go to the first slide? we can skip that. Okay. I think Yasmin has explained about the first major Indonesian civil code, but the key elements in the article of 1244 is it should be and it must be an unforeseen event. It cannot be reasonably predicted at the time the contract is signed. And the debtor is not responsible for the occurrence of the event. And the third one, he was not acting in bad faith. So this is the basic conception where, because the law doesn't really give a full description about the event and what kind of event that can be classified as force majeure. And in the next article, we can go to the next slide. So basically, Indonesian Civil Code explain or regulate this force majeure in 2 articles. And then it is Article 1255. The key elements in this clause is that act of God, the occurrence of the event cannot be controlled by human, or an accident happened. And then it prevented him in debtor, from doing his obligation, or in that kind of event, if he does his obligation, it's going to be a prohibited for him to do that. And then we go to the next slide. So those are the basic conception about a force majeure in Indonesian Civil Code. And then on 13 April 2020, the President Joko Widodo issued Presidential Decree number 12/2020 regarding the determination of the spread of COVID-19 as national disaster. And this is the very interesting point where a lot of lawyers and also legal scholar in Indonesia discussing about whether this is an announcement of a force majeure event, or this is merely, the announcement is merely for saying that we're dealing with COVID-19 situation where there will be a lot of hardship that the citizen of Indonesia will experience, but the impact of that hardship, it's really depending on the sectors that we're having business in. The impact of having this decree as social distancing is applied, partial lockdown in certain areas of Indonesia, mostly in the big cities, and then only certain activities are allowed. There are about 11 to 12, and then I revised into 13 activities that can still be done outside of your house. And one of the business activities that it excluded is in the energy sector. So basically, if we see the rate of the filing of bankruptcy in Indonesia, I think we only record 1 bankruptcy filing during the pandemic in Indonesian commercial code. I mean, only 1 company in energy sectors. And if we look at it, the history of this company, the filing is actually because this company has started its financial difficulties way before the pandemic has started in 2020. So basically, if we see in legal perspective whether this presidential decree, or whether in a broader sense, whether this pandemic is actually constituting a force majeure into your contract, the answer is it depends on whether your obligation is impacted by this COVID. We can make an example. Coal companies, they still got the same amount of demand for the coal for electricity. We don't have any substantial decrease in the demand for the coal. So for us, it doesn't really matter. It doesn't significantly affect or impact our business activities with the occurrence of COVID. And in fact, because everyone is working from home, the demand for electricity power is increasing. And it makes the coal price a bit goes up above the average even before the spread of the COVID. So in general, we would say that mining companies in Indonesia are not significantly impacted with the COVID. So if the questions is whether this considered force majeure for mining companies, we generally can say this COVID doesn't impact business activities of mining companies. So if a mining company declare that this is a force majeure, I think it would be something and even uncommon in Indonesian mining, because we don't see up until now any single mining companies close down their business because of COVID. And maybe the situation could be different if we go or maybe see another business sector, for example, property. I think until maybe November last year, there were already about 20 property related business filed bankruptcy, whether that voluntary bankruptcy or the creditors filed it with the commercial code in Jakarta, only during the pandemic. And we haven't count other business sectors where could possibly there will be a lot more bankruptcy filings for inability to pay their obligation to their creditors. I think in this type of business, the spread of COVID could and even significantly affect their business activities, where this will be a factor for company to declare this is a force majeure, because based on what we have in the field in Indonesia, especially, like this really significantly impact the business activities for property related businesses. Next slide, please. So a lot of discussion between Indonesian legal scholars and also practitioners, the impact of Presidential Decree number 12,020. Does it serve as legal basis for the debtors to declare force majeure? And the second question is, what contracts are affected? And then whether it affects all of the contracts or only the contracts that were signed before COVID-19 spread, or it includes all of the contract that signed during the pandemic. And where the point that we can classify a contract where pandemic is a risk for those parties who execute a contract during the pandemic, because they already know this is the obstacle that they're going to face if they sign into a contract, or it would be still a risk, or it would be still a force majeure event. And the next question is, does it apply the contract that are signed after the enactment of the decree? So before, there are different questions between the number 2 and number 3, whether the contract that is signed or execute after the pandemic can declare this pandemic as force majeure. And the next question is, does it apply whether the presidential decree will trigger the event of force majeure in a contract? And I think, as explained before by Yasmin and Brimanti and Hedy as well, and when we go to see and do some analysis about the impact of Presidential Decree number 12,020 in Indonesia, we need to see the impact and the obstacle that each of businesses facing because of the pandemic, because could possibly or arguably it only impact in certain field of businesses. Indeed, we would say that everyone is impacted and every business is impacted by the pandemic, but we need to see how significant the impact to the performance that is required under each contract. And for example, there are types and range of a contract, but I would quote one of the typical provisions in mining contract. We always have these provisions, what we call it, termination of contract because of economic unviability. So we don't actually say event of force majeure, but we put a clause that would be a result of force majeure where we don't see mining of certain field is economically viable. So the parties could always asking for termination if they can prove that this is no longer economical for them. And if we see the provision of Indonesian Civil Code that force majeure should be proved by the party who claims experiencing that force majeure event. And if in Indonesia, if we declare, I'm sorry, the question is whether Presidential Decree number 12/2020 is serving as res ipsa liquidator or prima facie, which the impacted party don't have to prove it anymore because the government already declared it as national disaster. So how the legal scholar and also the judges in Indonesia see the burden of proof, whether it is still relevant after the issuance of Presidential Decree number 12/2020, because it's already declared that this is national disaster, or whether the impacted businesses or impacted parties still have to prove that their business is significantly impacted by the force majeure. I think that's well presentation. We can go to moderator to moderate question and answer sessions. Thank you.
Thank you, Padre. I'm sure there are questions for Padre as well regarding to this decree, especially from practitioners. And now we will be moving on to our question and answer session. We have already some questions in the Q&A box, and I will address them by first to last. Okay. The first question here is addressed to Ms. Hetty. Okay. Somebody asked, does the interpretation of COVID-19 as unforeseen circumstances changes throughout the whole year according to Dutch law?
Yes, it has. The courts, the body of case law is still limited, but courts have been facing some cases in M&A transactions, which I've not mentioned before. But in that context, they have indicated that transactions, so SPAs concluded after March 2020, for those SPAs, COVID was a reality. However, they've also recognized that because the government intervention has been a bit of a snowball and it's changed, that parts of the pandemic can still be unforeseen for parties.
Thank you, Ms. Hetty. I hope that answers the question. And continuing on, we have a question for Ms. Brimanti. Ms. Brimanti, do you have any tips on how we as legal counsel make a business judgment in examination of force majeure clause, such as what are the factors that you can note before making a judgment? Or can you give us an example of your experience?
Yeah, that is actually a good question, because as a legal counsel, the first time I work as a legal counsel is with HMS International. So it's really different feeling when you work as a lawyer and when you work as a legal counsel. When you work as a legal counsel, you are exposed to more the business side of the company, where you can see like the business cases, and you know, I'm not really good at math. That's why I go to law school, right? So at that point, I learned how to see the business case, how profitable the business is, how's the relationship, and it's not only merely about contract. When you see like, oh, you have the rights and obligation there, it's not only about that. So you have to. My tips is what I did actually. I go to the business development department, and my boss, chief of legal counsel, like what things to look for. For example, the question, how is the relationship? Just simple question like, how's the relationship with the landlord? If it's good or bad, because it's gonna affect the way you negotiate with them, and how long is the cooperation has been established. If the business partner is really new, and probably we cannot really read them, but if the business cooperation has been established for 10 years or 15 years with that company, and we can actually know the pattern, how we communicate with them. And you also need to have like meetings with your colleagues actually, like okay, in the finance department, what are your concerns? So you have to communicate with each department, what are their concerns. For example, for IT also, like what are your concerns? Do you need any assistant from legal department in that sense? Yeah, I think communication is the key, and you learn by doing it actually. I don't know if it answered the question, but that's my experience.
Thank you, Ms. Brimante. I'm sure your answer is very insightful. And next on, we have another question for Ms. Hetty. Ms. Hetty, can you please elaborate on the difference between force majeure and hardship in a contract? And how can we determine whether COVID-19 is force majeure or a hardship? And I think for this, I think Ms. Yasmin can also add a little bit on explaining force majeure and hardship from the Indonesian perspective, because I know a lot of Indonesians, they know about force majeure, but I think hardships are something new, I think, fairly for law students here. Ms. Hetty?
Yes, thank you. So there are two angles to looking at these two provisions in my view. I am tempted as a lawyer to look at the remedies angle of these two provisions, but I will save that for last, because I think for the students, actually the doctrinal angle is more interesting, or at least closer to how they look at the law. But both are really important differences. So force majeure requires an impossibility to perform. And performance is rarely truly impossible. I mentioned, I think, maybe in passing a bit too much, governments issuing export prohibitions. That is an example of a true impossibility. Another example that we always teach our students is if you promise to deliver a painting, a unique painting, and it goes up in flames. That's maybe a more sort of more easy to visualize. A lot of the other measures that have been taken or consequences of the pandemic have led to performance being more burdensome on parties, more expensive, actually not economically viable anymore, or at least not for a period of time. Now, then you enter into the land of hardship or unforeseen circumstances, because there the obstruction doesn't need to be doesn't need to make the performance impossible, but it needs to make it so burdensome that the other party cannot expect that party to perform as per the contract. So the standard is still high, because in principle, pacta sunt servanda, and you're supposed to perform. But it can be the case that there are such circumstances that were not taken into account when drafting the contract that make it so that you cannot expect the other side to honor its obligations. Now that's the difference in short, but I think Ms. Yasmin may be able to build the bridge to the Indonesian perspective. And it's, as I also said, it's based on principles of good faith, and I think those you do know. So, and that was case law before it became part of our civil code in 1992. Now, if I look at it from a lawyer's perspective, actually the big difference is the consequence of invoking both provisions. I called force majeure a shield, and that's because it does no more than shield you from damages or a judgment of a court saying you must perform. And it still leaves all sorts of other remedies open to the other side, including termination. Unforeseen circumstances, while also not being the ideal remedy, because I think the ideal remedy would be a negotiated outcome, as Ms. Brimanti also suggested, you should also always consider putting in your contract. But it does allow for adaptation of the contract, potentially, by a court. So that's why the case law that we've seen, if you look at how the claims are phrased of parties, it's always first adjustment on the basis of unforeseen circumstances, and subsidiarily they'll ask for no damages and suspension of performance under force majeure, and the judge rarely gets to that bit. I hope that answers the question.
Thank you, Ms. Yasmin. Do you have anything to? Yeah.
Yep. So just to bridge the explanation to the Indonesian point of view, I think with regard to force majeure, the first thing that we have to look at, as Ms. Hedy has stated, is impossibility, right? But seeing from the Indonesian perspective, if you see it under Indonesian contracts, you typically see something like act of God, natural disasters, flood, earthquake. So it is something that is really, really absolutely hampering you from fulfilling your obligations. Whereas hardship, it usually refers to something like financial or economical distress. So it is not, it is still arguable whether or not you can still fulfill your obligation. And as such, the reason why force majeure is more commonly discussed under Indonesian law, it basically because it is explicitly referred to, for example, under the Indonesian Civil Code Article 1244 and 1245, whereas hardship, it is still, a bit of an abstract concept, and, financial hardship is a bit hard to prove, right? Can you say that you're running out of money that you can't pay? Like, parties may have to negotiate, and ultimately, if they choose to go to the court, then the judges will have to look at the evidence to see whether or not there is a real hardship that hinders the parties to fulfill their obligations. I think that is one of the main difference that I can provide from the Indonesian perspective.
I would like to add something, if
Yes.
I may. In my experience regarding the financial hardship, I also find that one, and we're required to prove that, right? So in that case, there is a request from the other party, okay, prove your financial hardship. And what we can do is actually providing them with the summary of financial statement. It was actually clear, right? When you actually suffer a lot of loss and your business is not being profitable. But the thing is, financial statement is gonna, if it's not a publicly traded company, is a confidential information. So you have to careful to reveal certain information. So, but yeah, that happens, and that's also one of the solution. Thank you.
Well, thank you. I don't know whether anybody has anything more to add. I think the answers are quite insightful, and I guess we'll continue on to the next questions. And this next question is not addressed to a certain speaker, so I'm not sure whether maybe the speakers would like to answer this in turn, or if anybody has this, if everyone wants to go first, I think that's okay too. So the next question goes like this. Certain jurisdictions give financial support through aid or subsidy to business owners in order for them to survive this pandemic. Can businesses that receive this financial support still use force majeure clause as an excuse in performing contract obligations? Are we going to take this in turns, or do any of the speakers would like to?
Well, I have that experience actually with one of the airports in Europe. So in that case, the landlord actually, we know from the news that the landlord will get certain funds from the government. So a certain amount of money for the government, but they're still asking the operator or the renter to pay the full amount of the rent. And at that point, we're still losing money because there's no passenger at all at the airport. So it's actually hard to keep up to pay for the full amount. And in that case, our argument is that to the landlord, hey, we know the fact that you will receive certain amount of money, and why are you still imposing us for paying the full amount? So there is a go back and forth discussion about this, and I cannot reveal what was the result, but that's also happens in Europe, basically.
Any other of the speakers would like to give a comment on this question? I think it's fine. I think if there's no more comments from the other speakers, I'll just continue on to our last questions for Padri. And this is interesting because we've been discussing on contracts of obligations, and but this question refers to contracts of labor. So Padri, somebody asked to you, can force majeure be a basis to stop employment contracts, considering that we see a surge in unemployment rate since COVID from the labor law perspective?
Thank you, but I have to be honest that I'm not an expert in labor law. But if we see just like as a follow-up from the previous questions, where as we know that the Indonesian government, we already gives a lot of subsidies, especially in tax field. One of the thing is the deferred for payment of income tax for laborers, where it is deferred for at least 6 months and then extended again, which means that the company, which previously they have to deposit some amount for the tax for the employee, it get deferred and get subsidy from the government, and now I think it's gonna be extended into another 1 year. And also there are a lot of subsidy. Let's say that if you buy some equipment or things outside of Indonesia, your import tax will be exempted. But the questions here, if whether after the subsidy and all the incentive that government already gave to a company, and then that company still feel that they're incapable of maintaining the amount of the employees that they have to employ, I think this is the questions that that will get very subjective answer from two different perspective. It depends on where you're sitting on. If you're an employee, you're gonna say that, how could you terminate my employment? Meanwhile, you actually get a lot of incentive for the government from the government, which the government mandate to be given is to maintain my employment with you, so you don't have to lay that off. But from the company perspective, could possibly that even though we get a lot of subsidy from the government, but it still cannot make us maintain your employment, because labor is one of the biggest costs, I think, especially where your field of business is labor intensive business. I just say that, just like Brimanti said, it's first, maybe if I'm as I in-house counsel, of course, like my perspective will be really subjective because I have to be in line with the interests of the company where I'm working on. So if the question is, could it possible to terminate using that? It is very possible if that is the questions. But the dilemma is whether it is really fair when and how to strike the balance between whether the subsidy that is given by the government is quite enough to cover your expenses to maintain your labor contracts.
Thank you. I hope that answers the question. And well, somebody personally asked me a question through the chat room asking whether Ms. Hetty has any point of view regarding this labor enforced majeure issue.
Well, in the Netherlands, the government was very strict. And if you wanted to have support from the government, you had to promise to not lay off employees. It doesn't apply to all forms of, we have very different arrangements, but I think by and large, certainly for the larger companies, that was a requirement. And it has caused companies not to opt for asking for support from the government because they did want to lay off personnel. And I do know of quite a few multinationals. It's a bit depressing, but almost every day there is a message in our financial times that a company like a multinational based in the Netherlands is planning to reorganize or reorientate its business. I know that companies like Nike have realized that having a lot of stores is actually not the future probably for their business model. So they have announced that they're reorganizing. And as I said, the list just continues and continues. But so far, the damage to our economy has been not too bad, surprisingly. Let's see what will happen in the next months or year. But I think the government support has artificially kept people at work at the moment.
Yeah, I can actually support that statement because in my experience, some of the companies, the reason why they got that money from the government, and the government actually make you promise not to terminate certain numbers of employees or certain amount of time, for example. Well, for me personally, my employment was also jeopardized by this COVID because my previous company is Horeca business, hospitality, and they've been suffering a lot of loss. So usually the policy is last in, first out. So I was the last one. So I get terminated, but lucky enough that I got another job offer from different company. Thank you.
Thank you, Ms. Rimanti and Ms. Hetty. And I think we don't have any more questions. So which means that concludes our webinar. And we hope that this third LEXINAR will bring new insights and knowledge to all the participants and also the speakers. And if it's okay, I would like to also ask the participants to fill in the feedback form, which will be shown in the slides, I think. But I don't see the slides now. Okay. Yeah, thank you. Right. So if it's not a trouble, we would like to ask the participants to fill in this feedback form. And again, I would like to say thank you to all the speakers and all the participants who has participated in this webinar. And I hope we can meet again in another series of webinars. And I apologize if there's any problem with my presentation. Thank you, everyone.
Thank you.
See you next time. Thank you.
Thank you, everyone.
Thank you very much.
Have a nice
Enjoy the rest of
weekend.
the day. Have a nice weekend.
Bye.